Hello, everyone, and welcome. We're glad to have you with us today. Our topic is successful alternative dispute resolution for your company. And this is part one of a two-part program that we're going to be delivering. This session, we're going to focus in on mediation and really look at some of the nuts and bolts of it and how to orchestrate a successful mediation for your company. Today, I am very pleased to have with me my partner, Ed Walton, and also Jennifer Bauman. And I want to give you a little bit of information about their background. Just so you know, we've got some very distinguished speakers here this morning. First of all, Jennifer Bauman, she is Executive VP and General Counsel with Alliant Insurance Services. She has been with them since 2008 and has a really tremendous track record, has led the company through some very impressive growth, 21 acquisitions, 4,800 new hires. They are the 10th largest insurance brokerage firm in the country. And so, Jennifer, thank you so much for joining us this morning. And I look forward to all of your comments. My partner, Ed Walton. Ed has the gray hair, as you can see. He has been practicing law since 1977, a super experienced litigator, very diverse experience in a lot of different types of litigation, everything from corporate partnership, fraud cases, real estate, commercial cases, environmental construction, a wide range of business torts, insurance bad faith, employment, professional liability, unfair competition, and interestingly, also personal injury, product liability, wrongful death, and admiralty and maritime law, in which he is a certified specialist. So we're very fortunate to have the benefit of all of his experience this morning. And myself, I also have a litigation background, started in 1984. And I've been with Procopio now since 2017. I serve as their general counsel. So I will bring a little bit about my perspective as an in-house attorney there. And I also have recently become certified to do mediation. And so I will give you some perspective there as well. So with that, unless there's anything Ed or Jennifer you would like to add, we will go ahead and get started.
I think you covered it.
Yeah,
Okay.
you definitely covered it.
All right, well, we'll circle back if we need to. The first thing we wanted to talk about was how things have changed. It used to be when I started practicing, and probably similar for Ed, maybe Jennifer as well, that we had something called a mandatory settlement conference, and it was run by the court and it was run by the judge, and things have changed quite a bit. What we are really seeing now is that people are relying very heavily, in my experience, on the process of mediation in order to resolve disputes. And I think that has benefits and detriments. And one of the things that I think is a big benefit is the professionalization of mediation. There's obviously extensive training. There are professional service providers that really specialize in mediation. So instead of getting a judge who may be very busy on the morning that you happen to show up, or an attorney who's volunteering to throw in a free hour, you are getting a very robust, professionalized process. And that has changed the game, in my opinion. Ed, some thoughts on this change to a focus on mediation?
Yes, since I've been correctly painted as very old, I will reach back to my early experiences in San Diego, and with the Superior Court in particular. That Carol's exactly right. The way to proceed with settlement conferences when I began practicing in the Superior Court here was to be assigned to a judge who was really a trial judge or a law and motion judge or whatever, who kind of moonlighted as a settlement judge. And it was hit and miss. You really didn't know whether you're going to get somebody that had the time or interest to do it, and to do a complete job. So this whole business of alternative dispute resolution, and in particular mediation, kind of arose out of the court's inability, I think, to be able to provide the type of services that were needed and the amount of services that turned out to be needed in order to be able to satisfy the legal community. So I've seen that change over time. And of course, there's still a little bit of hit and miss in terms of the mediators themselves and their ability to help resolve disputes. But that's where networking and conversations among lawyers comes in very handy. Reputation of mediators is a really important piece here. Whether they've gone to a mediation school or arbitration school really doesn't count as much as people's satisfaction with their ability to preside over mediations and hopefully bring the parties to a successful conclusion.
Jennifer, some thoughts about benefits or detriments of the mediation process that we're now all immersed in?
Yeah, I think there are some definite benefits to the process. You know, it brings the parties to a table and kind of forces, in the spirit of compromise, the discussion to go forward. And I think, you know, one of the things I was thinking about as I was speaking is that the role of the mediator is so different from that of a trial judge, and the professionalization of the mediation process, I think, is key to its success, because a trier of fact is trying to adjudicate who's right and who's wrong, right? And the goal of the mediator is to find the compromise, is to build a bridge. And likely when that compromise is found, no one's going to be 100% happy, but the goal is to find that space where, you know, the parties can exist and agree to move on. So I think that, you know, the focus and the goal of mediation is different and unique from the trial process is an important component to consider.
You know, all of us have been also, because we're not limited to a judge who has an hour anymore, all of us have spent late into the night engaging in mediation. And I think that's both a detriment and a benefit. You have somebody who will just sit there until you can get it done, which and keep you working and working and working at it. But it can be very tedious. It can be very tiring. It can be very slow. Because of this, we no longer have the free settlement conference included with whatever you're paying to the court system. Mediation has become, in some cases, it can be quite expensive. I know there's a big debate. Do you get what you pay for? I hear tales of certain mediators who are making a very large amount for just one day, but they have developed their skills to the level that obviously people are paying that and they think they're worth it. Thoughts on any of that, Ed?
Yeah, I'd like to pick up on something Jennifer said, which is what the goal of the mediator is. And I think that dovetails into what the issue you're raising. I tell my clients that routinely before a mediation that, look, you're going to meet somebody who's going to be versed in the facts and law applicable to your case, and you're going to want to have me earnestly advocate your position. and I will, but remember who this person is that we've employed. That this person, his or her goal is to bring about a settlement. The merits are really, they're interesting because they provide a platform or leverage for the mediator to make recommendations about where and how a case should settle. But at the end of the day, the mediator's job is to bring things to a conclusion, and it may be a very unfair conclusion if it were to be judged by a jury or a judge who's supposed to be evaluating the facts. That I think it's key to recognize that going in, so that you know that your lawyer is fighting for you, but the strategy has to be one to try to convince the mediator at the end of the day that you will only go so far, and convincing the mediator of that, whether you're the plaintiff or defendant, you're only going to go so far in terms of resolution, and convincing the mediator of that so that he or she is not carrying the wrong message in his or her head, or talking to the other side thinking that they're going to be able to bring you to a conclusion that's in the middle, or is a rough justice or something like that. It's more along the lines of, can I get this done? So I think it's just important to remember that as you approach your mediator.
Thank you. The final benefit is confidentiality. We now have a lot more protection as to what is said in mediation, and the pretty clear inability to use it later for anything. How do you think that's affected things? Jennifer, do you have some thoughts on that?
Sure. I think the confidentiality umbrella invokes more candor in the process. Parties are going to be more inclined to speak freely, openly, maybe divulge a little more information, that knowing that it can't later be used against them. So I think that, and that can be a process to, we talk about building a bridge to compromise. The more you know about what's motivating the other side, and maybe the more they know about what your motivations are and what your limits are, and having that candid, forum or space in which to speak can certainly help in some circumstances to facilitate that conversation toward some resolution.
Okay, I'm going to turn to another topic now. Thank you, Jennifer. We wanted to find out from our attendees. So we have a polling question about this, I believe. Do you have a mediation clause in your contract? So you can vote, and it's kind of jostling back and forth there. What we're talking about is a contractual agreement that you will mediate something before you get into litigation or arbitration. Okay. We have a bunch of people voting. So thank you for that. It looks like about 40% do, 50% don't, 10% are unsure. So they're going to have to go back and look it up. But this is an interesting thing. If you are in a certain type of business, involved with certain types of customers, it may make sense, or even with your employees, it may make sense to include a mediation clause in your agreements. And if you want to find any number of samples, you can go to any of the major mediation providers, and they have a wide variety of clauses for just about anything you could possibly imagine. And there are some variations. The variations can involve who pays, whether you have to do a pre-dispute, or whether you may do it if anyone so decides to do a pre-dispute. And so you're going to give some thought to the potential of having a pre-dispute mediation clause that would allow you to resolve the dispute before even an arbitration is started. And so let's talk for a minute. What are the benefits and detriments of having this type of an arrangement? Ed, what are your thoughts?
I see these clauses in contracts a lot where there's a third party who's involved in structuring a deal, and the third party may have a dog in the fight, and like a broker or someone who feels like they want to influence the parties to resolve things quickly if there is a dispute. Other than that, if you're a party just entering into a contract and you are trying to consider whether you think you need a mediation provision in addition to an alternative dispute resolution clause, such as for arbitration, you got to consider the cost. You got to consider the things that Carol mentioned originally, and whether you think that your relationship with the party, at least at the time of contracting, is going to be is something you think is going to lend itself towards people spending their time fruitfully in litigation. If it's a contentious situation in the beginning, it's probably not worth putting a mediation clause in, because it may not. It's just going to probably extend the time and resources spent on it. But there's a lot of different kinds of mediation clauses, and we can talk about those, or I think we probably will, but that you could put into a contract. And again, this is only in a situation where your pre-dispute situation is premised on a breach of contract. You can always, before you file a lawsuit, the parties can get together and agree to select a mediator, regardless whether it's in your contract or not, or regardless whether there is a contract or not.
Good point. Excellent. Jennifer, what are your thoughts on this? I think in our discussion you said your company does not have pre-dispute mediation, but what are your thoughts about it?
Yeah, I mean, I think we don't have them regularly included in our templates, or we don't necessarily request them, on a, we don't normally request them when we're negotiating contracts, with other people on their forms. And a lot of it is driven by our own lived experience. Fortunately for us, and I'm knocking on wood, breach of contract matters do not form a big part of our disputes or litigated practice. But if we did have an experience, whether it's in a particular type of agreement that did seem to lend itself towards, breach of contract, disputes on the regular, we may be more inclined to consider whether or not a mediation provision would be appropriate. I think, I think Ed's point about, the relationship of the parties is an important one to think about. If you're already kind of at odds and it's a tough relationship to begin with, does having a mandatory mediation provision where you're going to have this early outlay of expense to try and resolve the matter make sense? Maybe not. Sometimes, in those instances, just informal discussions between the business folks before you lawyer up, you can't be productive. The relationship is still salvageable, perhaps. The dispute is early on and no one has invested a significant outlay of money to try to litigate or resolve the dispute. And so a reasonable financial resolution may still be attainable.
Thank you, Jennifer. I think we're going to explore this a little bit more. Let's say you do want to do a pre-dispute resolution, or you want to have a clause. You're going to have to think a little bit more deeply about what provider you're going to use and what panels they have available. I think depending on the subject matter and who your likely counterparty is going to be, you're going to want to look at the rules. If you're going to be dealing with consumers, you want to make sure that the rules will allow for that appropriate type of mediation. If you're going to be, same thing with employees and employers. I suggest that you anticipate the possibility of pro per parties in mediation, and not all providers will accept mediation matters with pro-pers. Not all providers will, not all individual mediators will. And I think the reason for that is they could be very challenging. So you may want to check with your provider that you're interested in using and make sure that they'll deal with it. And then let's talk for a moment about, we've already kind of alluded to this a little bit, judges versus non-judges, and how much does a particular mediator matter? There is often this big song and dance about this mediator, that mediator, plaintiffs mediators, defense mediators, and many other factors which get weighed in when we're trying to decide who should mediate a particular matter. Sometimes very hard to come to agreement with your counterparty about even choosing a mediator, especially pre-dispute when emotions can be running very high. Somehow, yet, if we want to mediate, we've still got to get that done. What are your strategies, Ed, that you try to advise your clients on in going through this process? And what do you tell your clients about judges versus non-judge mediators?
So I personally think mediators matter. Their personalities, their approach, their ability to get along with people, engender trust, those sorts of common human attributes, I think, are pretty important. Judges in general are probably among those who would make good mediators. There's a whole variety of reasons for that. Sometimes a judge is a black robe and makes a lot of difference to parties on one side or the other in terms of being someone who's experienced and knowledgeable and ought to be respected, and whose views ought to be respected. And that sometimes works on one side or the other, your client or the other side's client, with respect to getting that client's mind right, so to speak, about what the realistic possibilities are of going to trial. But it can be taken too far. There's plenty of good mediators in my experience out there who are just former trial attorneys who've seen a lot, know a lot, have a good feel for what a jury might do with a particular set of facts. And again, this business of salad. Carol, you're muted now. I was muted. Now you're muted. I don't know what happened.
I think we lost you when you were talking about good trial attorneys who have a good grasp of what a jury might do.
Yeah, and now Carol's muted again. So, well, at any rate, not to belabor the point, but the idea of finding the right mediator, in my view, involves again, this sort of networking and talking to other people. What was your experience? What were the good things and bad things about any particular mediator?
Yeah, I agree with that. Yeah, I was going to say, I agree with that. Finding recommended or recommendations, or people who would say, yeah, don't go with this person. The converse of that is really beneficial and valuable. Having that kind of personal insight into the skills of a mediator is really important. And I agree with that mediators are important. And, there's no one size fits all kind of mediator. You really have to think about the parties who are at the table, the matters that are at stake. In some instances, it may be that you need someone with more industry expertise because your dispute is really technical and difficult, and someone who really has had some deep experience in the industry or in your particular litigated issue is really useful. And you couple that with the personality of the mediator and the ability of that person to be able to build that bridge. And so, in looking at retired judges or attorneys who can help, these are folks who are used to are trained to adjudicate and litigate to a resolution of who is right and who is wrong, or who's liable, who's not. And, you know, having someone who also is able to balance that skill with the ability to reach a compromise, which may not reflect what would happen at trial, is really important. And someone who's able to communicate that back to, you know, say me as the client sitting at that table and making me understand, you know, kind of the nuances of all of that is important.
Okay, thank you. Thank you very much. So, so anticipating and negotiating your mediator is going to be a very important consideration. And then once you get them in place, you are also going to have to think very hard about the timing. And so we've talked a little bit about pre-dispute mediation, advantages and disadvantages of that. Primarily, once you are in litigation, that does ratchet things up, usually. But it's hard sometimes to put together a pre-dispute agreement. It depends on many factors, of course, but sometimes the parties can be very, very locked into their positions. Once you do have that dispute in process, you may want to mediate at that point. And there can always be a discussion about, do we want to mediate pre-discovery or post-discovery? Some people will say, I really want to get the plaintiff's deposition locked down first. I want to lock them into their story. I want to get their responses to certain discovery so that we're not giving away a lot of information in connection with the mediation. That is also something that I think it's a lot of discussion. And then we've also got to take, in many cases, the insurance carrier and its evaluation into consideration as we are trying to decide when to mediate, because the carrier will want to know a certain amount of information about the matter in order to know what would be an appropriate resolution of the matter. So all of these factors get thrown into the mix. And I believe we have a polling question here for our audience, our second polling question about when is the best time to mediate? Prior to litigation or arbitration, or during is the question. So just weigh in. You want to go to mediation prior to the lawsuit getting filed, or you want to just wait, because then you'll know a little bit more about the parties' positions perhaps during the litigation. Okay, so we're shifting around a bit here. And I really think there's good arguments for both, and it can often very much depend upon the type of case, the type of business that you're in, the type of industry. So looks like so far, well, some people are not playing the game, but that's okay. That always happens, right? But it looks like so far, 57% are saying they would like to prefer to mediate prior to a dispute and to litigation or arbitration, and the remainder are during. So that's kind of interesting. Ed, how do you think about this when you're advising your clients?
Well, it's I mean, it's probably a matter of efficiency, and probably that may well be why we have this split here. To me, mediation before litigation is preferable simply because it may resolve the dispute without having to spend a whole bunch of money on litigation, which is in an entirely different world than a mediation. Even though mediation can be expensive, litigation, as everybody on this call likely knows, is an extremely expensive proposition no matter what you do. But in terms of, if you want to just evaluate it in terms of whether it makes sense and what are the odds of success, to me, it seems like the simpler the dispute, the more concrete it is, the more black and white it is, as opposed to having many issues, both fact and law, the more likely it is that you could get yourself into a room with an experienced mediator and bring the thing to a conclusion by unearthing, here's the kind of the odds of this and the odds of that, and what would, how can we bring this to a conclusion in a way that's satisfactory on a very simple set of facts, simple legal issues. I think it's a lot harder if there's a lot of issues, both factual and legal, that people aren't really up to speed on yet, and then lawyers are very concerned that they're leaving something on the table, or they haven't considered something fully, and so they're not in a position to fully advise their clients. And that might end up being a fool's errand, because nobody's really prepared under those circumstances to mediate to a conclusion.
Jennifer, what are your thoughts as an in-house general counsel on timing?
Yeah, I echo Ed's statements that it really kind of depends on the case. It depends on the history that we might have with the other side and the facts that are known to date. If the matter is pretty straightforward and perhaps we have the benefit of knowing most of the critical facts and understanding the law at hand, it may make sense that we try mediation before litigation is filed. But it really is fact driven. In absence of kind of knowing the lay of the land, I would tend to want to have some discovery done, just so that way we have a better understanding and a better footing on the different issues. When I was thinking about pre-discovery or post-discovery, it's a little bit of a double-edged sword, right? If you do it pre-discovery, you don't know what you don't know, right? And they don't know what they don't know, which could be good or bad for you, right? So if you have some facts that you'd rather not share because it might you might lose some leverage, doing mediation pre-discovery may make some sense. I think it's a really fact-driven question, and one that needs to be considered each time.
All right, thank you very much. I saw we had a question in the chat, and thank you for that. Feel free to post your questions. Who are the major mediation providers that you could find sample mediation clauses? I think for me, JAMS, Judicate, West, and probably AAA, American Arbitration Association. That's where I would look. Any other suggestions, Ed or Jennifer?
I actually did a mini search last night on that question, just because I was curious. The three you mentioned do have such forms. ADR Services Inc., insofar as I could tell, does not. And I think it really sort of depends on the provider. If they're just saying, look, we provide people and good luck, we've got an organization by which we can sort of designate people that have experience. We give you their biographies and you figure it out. Or whether it's a more, full service sort of operation for alternative dispute resolution, of which those three that you mentioned are clearly, that's what they're in a business to do. And they do have a myriad of forms. I mean, they got all kinds of stuff that you may find useful, both pre-dispute and during dispute, to try to get things resolved.
All right, let's continue. We just have, during the pandemic, completed the biggest experiment ever in online mediation because we couldn't mediate live for a long period of time. I am doing live mediations again. I have one coming up in a couple of weeks, but did online mediation during the pandemic. And I have a background in online education, so I already knew a lot of the benefits of it, but some of the things that have come out as benefits that people really appreciated. Number one, convenience. I do not have to drive somewhere, go somewhere, park somewhere, be stuck there all day. And when I'm done, I'm home or in my office, wherever I'm doing the online from. The surprising thing, I think, has been that many studies so far showed that online mediation has been very effective. I don't know if we could say it's more effective, but time will tell as everybody delves in and analyzes that. But at least it wasn't ineffective. And so we did get some cases settled through online mediation. But there are some downsides too. Jennifer, I know when we talked, you've done a bunch of online mediations. What are your thoughts on the pros and cons? And will you keep doing it going forward? Or are you going to switch
Sure.
to live and in person again?
I think it depends, right? It'll depend on the case. I do think that there are some definite advantages of being able to do it at home or in your local office, not having to travel, especially for those prolonged sessions. You're not feeling kind of that pressure of being at the table all day and kind of away from kind of your home or your office. I mean, which can be a benefit to the mediation process or a detriment, right? So, I mean, if you're physically away, that might, cause parties to be more compelled to reach a compromise at the end of a long day. But I had an all day long into the evening mediation at home, and we were able to reach a resolution at the end of that day. And it could have been because we were more willing to have staying power because we weren't, outside of our kind of comfort zone. So there's the pros and the cons. Another one of the possible pros is that it kind of brings this more human aspect to it, especially doing it in the pandemic where, a lot of us aren't working from offices or working from home offices or our dining room tables. And, so it just, you get folks out of that kind of, professional environment or traditionally professional environment, and it just kind of brings a different human element to it. And I think that's paved the way to some good conversations and helped build bridges for compromise. So I think there are some advantages. One of the disadvantages could be that is because we're so apart that maybe in some instances the pressure is not on the parties to settle. I mean, I've been in situations where you travel across the country and sitting there in the mediator's conference room or in a judge's settlement conference chamber matters. It shows seriousness and intent to resolve. So I think that it really, your question was, would we continue to do it? I think it depends on the situation. There may be circumstances where it would be more effective to do it in person and get parties around the table, and there are other instances where it may be just as effective to do it in a remote environment.
Yeah, I think that I agree with you. Ed, do you want to be the devil's advocate on this?
Well, since I was in our pre-meeting, yes, I will say that I agree with all the points that Jennifer's made, and I also think that the jury is out on this, so to speak, with regard to whether it's going to be more effective or not so effective. Now, as you pointed out, I'll call it experience as opposed to age, Carol, but we didn't have this opportunity, and it's always been important to me to get a feel for the room and to be able to catch body language in my periphery and to be attentive to what everybody's doing and how engaged they are, and with the ability to shut off your screen or to be taking notes or to be, and the mediator not really having a whole lot of control over that in a remote setting. There's a lot of distractions that can make it difficult to have that kind of read of the circumstances. So I don't know where this is heading. I do know, for example, that I'll just give you one. For instance, I had a mediation earlier this year with a mediator, and it was remote, and I could sense that the mediator wasn't, he and I weren't connecting. I can't imagine why not, but anyway, we weren't connecting. And he was good enough to tell me that he thought that my body language indicated that I didn't agree with him or that I thought he was wrong or something. felt that that made the situation harder for him and ineffective. And I appreciated that he was willing to share that with me. We talked it out, figured, you know, no, that's not what's going on. Let me explain. But it took 20 minutes to straighten out that issue. And I'm not sure all mediators would, you know, confess to what they're really thinking. But it was a misreading, I think, because of the Zoom circumstances. So, and I learned a great deal from that in terms of making sure that I'm not, you know, grimacing or moving around in a way that might be perceived as being disinterest or, you know, a pshaw, you don't know what you're talking about, which I had never intended. I thought the guy was actually ended up being pretty effective, and he settled it. It helped us settle the matter in mediation. But there can be that kind of miscue, and without some more experience with this, it's hard to say.
So, you know, I wonder.
Go ahead.
I was just going to say, I wonder one of the drivers of the efficacy of these Zoom mediations during the pandemic is the fact that, you know, the trial courts weren't available. And so, you know, and they're still not to a certain degree because of the backlog. And so, you know, my thought is that whether or not, you know, online mediation is as effective or more effective is really a story that's going to be told later on once, you know, the world kind of opens back up and our more traditional, you know, pathways, you know, to litigation or arbitration are more available.
That's a very good point. I think that's right. We'll see if people think it's effective or not if they keep doing it, right?
Mm-hmm.
All right. So let's talk a little bit about mediation procedures. And there's many things we could delve into here, but one of the big questions is, do you want to exchange your brief with the opposing parties? Or do you have two briefs? You give one to the mediator, you give one to the opposing parties. And I think we'll probably all say those two little words, it depends, which are very important in all of this decision making. Another interesting issue, and I've been doing this more and more and seeing it more and more, is the use of key documents, key evidence, and even experts during mediation. I had one mediation where the mediator himself requested that we give him the 3 most important documents in the case. And because of the type of case, that made sense. I'm not sure it would make sense in every case. I've had several mediations where an expert opinion was offered, and on one issue or another, I think it did carry some weight with the mediator, who was able to go back to the other side and say, well, they have an expert opinion that says whatever it said. And then I had one more mediation that I thought I would mention, which was where I thought a document was used very effectively. Somebody in the mediation was taking the position they could not afford to pay the settlement, and immediately that person's asset search report was provided to the mediator by the opposing party, who could very clearly then see that, oh yes, they absolutely could afford the settlement. They may need to sell one of their airplanes or et cetera, but there you go. So it was a kind of interesting use. I think this is coming up more and more. I'm interested in, Ed, what are your thoughts on this?
The issue of confidentiality plays into this, and we didn't spend a whole lot of time on this before, but just to sort of set the stage, there's two levels of confidentiality. There's the overall confidentiality of the mediation itself, in which you're sharing information that that can't be used against the opposing party or against you. But always remember that that information can be then investigated, and if you develop the evidence that's associated with that information independently, you then can use whatever you develop independently. And so it's not it's not all lost if you have a confidential meeting where you're sharing information. The second part of the confidentiality piece is that you can provide, as Carol said at the beginning of this, a confidential brief to the mediator that says, hey, look, I don't want the other side to know about this. Might be an issue of credibility, or but perhaps the asset picture that they don't want just sort of blurted out. Initially, where you tell a mediator, we expect them to take the position they can't pay for it. Look at this, but I want you to keep that confidential. Again, this goes back to the issue of trust. There has to be a certain level of trust with the mediator, but if you think that it's important that the mediator be armed with information that he or she says, I will not share with the other side, and you trust the arbitrator not to do that, which is not the case mediator is not the case with all mediators in my experience, but most. I mean, if a mediator tells you he or she's going to keep something confidential, that's generally what happens. And it can be a very effective tool because a skilled mediator can use that information, not overtly, but in a way to effect movement or provide arguments or sort of derivative information that might make the other side think twice. That I just want to share my thoughts about that part of it.
Excellent, excellent. Jennifer, do you have a practice on your preference on sharing information in your brief with the opposing party, or is that a case-by-case decision?
Yeah, I would say generally it's a case-by-case decision, but our common practice, it seems to be more often than not to share the mediation brief with the other side. By the time we are mediating our matters, most of the time, the parties are pretty well versed in each other's position. We know, the strong arguments, the weak arguments, and, in our experience, sharing these mediation briefs doesn't do much to facilitate the goal of compromise and settlement. It just kind of sends folks to their separate corners again, and maybe fosters some some emotions and feelings or attitudes that are not conducive to reaching compromise. So generally, we don't share mediation briefs with the other side.
And that is my experience as well. And I agree with the point that, Ed, you were alluding to about making sure your mediator knows what they are authorized to share and not authorized to share. Mediators should be pretty careful about that and abide by the parties' directions on that. So communicating that very clearly to your mediator will hopefully help them abide by that.
Okay. Can I make one more point just to follow up to what Jennifer said? We used to, when we first started doing this mediation business, the mediator would bring you into the room and you were expected to make what amounts to an opening statement where you marshaled out all your arguments as to why the other side, was just bad people, from the lawyer to the file clerk. And so this would go on for maybe, half hour, 45 minutes. And by the time you got done, nobody was interested in resolving the matter. Everybody was just ticked off, hated the lawyer on the other side. And it's amazing it persisted as long as it did. So I would, it doesn't happen. I mean, I haven't had that happen to me in a long time in terms of, giving an opening statement. But I think that Jennifer's point is really well taken with regard to sharing briefs, because my experience is that oftentimes all it does is surface the opening statement that drives people to their corners. So.
Excellent points. Okay, let's shift gears a little bit and talk about the role of in-house counsel. Jennifer, why don't you give us your thoughts on if you're engaged in a mediation, what is your role as in-house counsel?
Yeah, so I think your list here is pretty solid, but just to kind of expand on it a little bit, in my role, when I'm sitting at the mediation table, I bring authority, right? I coordinate the discussions with the appropriate business folks beforehand. We get kind of our strategy in order between, with us and our external counsel who will also be at the table. But, usually I see myself as someone who's there to bring kind of the legal, the legal-based solutions that are really business driven, if that makes sense. My goal is for us to find a compromise that our business teams can live with. And when we're talking about non-monetary terms, so you take the financial aspect of the settlement off the table, sometimes there's some pretty big asks, from the other side or from us that we really have to consider. If we say yes to these asks, can we operationalize them? Can we enforce them? We don't want to sign up for something that we know we're going to violate, the minute the ink on the paper has dried. So, my goal is to, be there to help liaise between, our external counsel, who are our gladiators, who are fighting the fight and making the case, and then also, making sure that whatever settlement, goals our business team has, are reached to the extent that we can, and sometimes, that liaison position involves, kind of communicating back to the business team the mediation is not something that they do on the regular. This is a very, unique, experience that can be uncomfortable, can be a little bit intimidating. And so I can build a bridge, between what's happening with the litigation team and the business team to make sure that we're all communicating effectively and reaching the common goal.
And Ed, in your role as the gladiator, as Jennifer called it, which I think is great, what is your thinking about the role of the in-house counsel that you're going to be working with in connection with the mediation? What should their role be?
So I agree with what Jennifer has said, and I think the role of the in-house counsel is very important, can be extremely important. If to the extent the in-house counsel is engaged and wants to be involved in the litigation process, there's a lot of one thing is clearly this idea of understanding the client's stomach, if you will, for litigation. It's important to know that as a litigator, just how far you should be pushing things and whether the company is going to end up being satisfied with maybe not so, like a knockdown, drag out, I beat these guys up terribly kind of fight, and would rather simply, move on with life, pay maybe a little bit more than what they think it's worth, but just to, to get it done. And I think your in-house counsel is a very important part of understanding sort of the, I don't know, the character and makeup and psychology of the company and in terms of their appetite for litigation. And in addition, I think that the in-house counsel provides a very good opportunity for the gladiator to gladiate and let the in-house counsel be kind of the tough face of the company or the more forgiving face of the company, as the case may be. This sort of shades into this business of what we as lawyers always run into as a bit of an issue in terms of ethical requirements, and that is the pointed question: how much authority do you have? And I like to not be in a position to have to answer that, or I just refuse to answer. I mean, it's better than lying. So, but it might not engender really good feelings to to whoever's asking you that question. But if you're just a gladiator and you really don't know what the ultimate authority is, hey, go on and gladiate and make the best case you can, and then the in-house counsel who's participating along with you at the time of the mediation can parse out what he or she is willing to contribute based on perception of how it's going, what goals are being accomplished here. And you, as the litigator, can just concentrate on fighting a good fight.
Very good. So let's turn to critical topic, breaking through impasse. There comes a point in every mediation where people will utter the words, well, it looks like we're not going to be able to do this. It looks like nothing's going to happen here. And the mediator's job at that point is to help the parties figure out a way to continue on if that is not the case. We've all been in many mediations where it started out at $5 million and $10,000. And everybody probably looked at each other and said, oh, well, why are we here? This is not even gonna, nothing's going to happen. And yet, as we know from going through that 12-hour marathon, you can end up settling even that case where parties are starting out at that great of a divide. And so impasse can really happen anywhere throughout the day. There's many different ways around it. Setting aside the merits, focusing back in on the merits, taking a break, going to the other side and saying, let's try a couple of different techniques. Let's try perhaps some bracketing. And I know there's a lot of strong opinions on bracketing. I've seen bracketing be successful where people are inching their way toward each other at a $10,000 increment. And they're already 5 hours into the mediation. You can say, okay, so if they went to $1.5 million, what would you do? What would you actually be able to do? Or you can reverse it and say, if you would go to 100,000 rather than 10,000, what would you expect them to go to make a big move? What would work for you? So instead of getting the parties to agree to a bracket, you can just get them to negotiate in, it just kind of speed up the negotiation through somewhat of a bracketing related technique. You can also try to do a mediator's proposal. And I think this is very effective. I have had cases that settled with the mediator's proposal, and I've had cases that have fallen through. But where you are still somewhat significantly apart, and your mediator may suggest, would you be interested in a mediator's proposal? Or one side or the other may suggest it. This will allow the mediator to really use their knowledge that they've developed over the past hours of the mediation, and where they think the parties, after listening and hearing both sides for quite a while, reading everything, where they think the parties would be very likely to come out. And it's not something that is mandatory. None of these techniques are mandatory, but they're just techniques to try to change it up a bit. There's always the projecting into the future and the litigation budget that might be applicable, and the possible decision of a jury that could be, as we know, unpredictable. And sometimes people have just gone as far as they can for the day. They've exhausted their authority. It's 10 o'clock at night. Let's come back next week and reconvene. And in the meantime, let's try to think about what would make sense. And I've had that work, and case has been resolved, even coming back after a month for further review of evidence or whatever it may be. Expert witness opinion came into play in one case. So all of these are different styles and techniques that we could use. I'm interested in, Jennifer, what do you think has been effective in your experience in breaking through impasse in the mediations you have been participating in?
I mean, to some degree, all of these have, in one way or the other, for different cases and for different reasons. I think the ones that we've probably used the most are the mediator's proposal, the bracketing, and then just kind of considering future events, likely future outcome. The mediator's proposal, to your point, it's never, I think what's important is setting the client's expectation when you're getting, you know, for me, it would be my business team's expectation when you're getting a mediator's proposal. It's usually not going to be something that's going to make either side super happy, right? It's going to be higher than you want to pay if you're going to be the paying party, and less than you want to receive if you're on the receiving end, right? And so I think setting expectations is important to making a mediator's proposal effective. And when we've asked for one or suggested one, you know, we tend to we've read the tea leaves a little bit and can kind of guess where that mediator's proposal will likely be. And we're usually pretty close, you know, and to your point, sometimes it's not accepted that night, you know, and it's something where we have a time limit on, and it's to be considered over the next, you know, 48 hours. I think our preference when we're at the table is if we can try and get it done in one session, you know, while everybody's there and everybody's invested, and, you know, the conversation is fresh, you know, our preference would be to stay and see if we can get it done, you know, rather than taking a recess and coming back later. But the mediator's proposal, whether we agree to it that night or a day or two later, has been effective. Not in every case, but in some it has. The bracketing is interesting because, you know, it seems to lead the conversation towards some midpoint. And if you're not interested in that midpoint, whether you're on the receiving end or the paying end, I don't know how helpful it is. And so I've seen it be, you know, in my experience, there's been instances where, you know, the parties are lobbying alternative brackets across the table, or they'll lob an alternative bracket, or, you know, a flat, you know, sum that's either demanded or offered, you know, to try and get away from that midpoint. So, you know, I think bracketing can be useful in carrying a conversation forward. I don't know that it's been the tool that's actually, you know, gotten the matter resolved, but I think it's helpful sometimes to kind of get discussions that are maybe stalled moving forward.
Very good. Ed, share your thoughts with us on breaking through impasse and any techniques that you may love or hate, either way.
Yeah, these are all techniques that I've been involved in one way or another over the years, and they're imperfect at best, but the whole process of mediation is pretty imperfect. The bracketing I'm a little nervous about because it's pretty nuanced. There's kind of an appeal, you know, you get this sort of range, you know, I'm at the lower edge of this range, and you know, I'm only going to move up a little bit, but I think it's a bit of a shiny lure, and it can be a real slippery slope to getting you in a position where you may have given away a little bit more than you expected to. It's a very nuanced process, and I don't feel comfortable unless I'm really, you know, in the thick of it, rolled up sleeves, really think I've got a great handle on it, doing, including a reading of the mediator, doing bracketing. So I try to stay away from that. The mediator's proposal, I go back again to referencing, remember what the mediator's job is. His job is to bring the parties to settlement, not to be fair. And I think, although, yeah, that doesn't mean he or she can't be fair, but you shouldn't see that as a goal. Your client, most importantly, should not see that as a goal. The goal of mediator's proposal is to get the case resolved. And in that process, understand that you may end up on the short end of the stick because the mediator reads your client as being willing to go farther away from the stated position than he or she reads the other client, the other side. And therefore, the proposal is going to weight more towards the party that he thinks is less willing to give, because that's the way you get it settled. So that's not always a good, a good mix either, or a good solution, though it can be effective. And the one thing we didn't talk about is baseball arbitration, which sometimes these mediations turn into where the parties, both parties take a position and say, this is what I'm willing to do or willing to take. and they present those numbers to the mediator, who now turns into an arbitrator. And the arbitrator has no authority but to pick one or the other number. Pretty exciting. And it's modeled on, Major League Baseball's arbitration methodology. It's something you could agree to, on the fly. You could agree to it before you even go into mediation. You can, there's a lot of ways to do it. And I believe there's case law to the effect that it's an approved method, and because the dissatisfied party is going to want to get out of that if the proposal is that party made is not accepted.
Well, we are just running toward the end of our time, but I wanted to finish up today with one more important topic. And then I wanted to welcome everyone to please put your questions in the chat, and we'll be happy to answer either privately or we can answer during the video right now. And then you can also reach out to us afterwards if you need to. We'll be happy to speak with you about any of the topics that we're talking about. Most important slide of the day and topic of the day: any resolution should be written and signed. And, people will wake up the next morning and change their mind. And we've all seen that happen, even if something is signed. But so think about when you're going into the mediation, not just the money, of course, but all the other terms that you need. And you can even circulate a settlement agreement prior to the mediation with the number blank and try to pin things down. I have done that in particularly contentious case, and it had an interesting effect of making everybody think we were going to settle the case, which I thought was kind of a side note. But if you can do the whole settlement agreement, which sometimes can be done that evening, then sign it, get it done, be done with it. If you are not able to do that, you can do a writing that is going to be enforceable under the Code of Civil Procedure. And you should list, and your mediator can help you with this, you should list all of the terms that are critical and provide that the parties will enter into a settlement agreement in a standard form or a usual form. Include all of those specific terms. If you're giving mutual general releases, you should spell that out. If you're waiving Section 1542, you can spell that out, and have people sign it that night. And then you will be able to enforce that conceptually, even if you, even if it doesn't mean it will be easy, but even if you can't get a settlement agreement, you may also want to ask the parties to agree that you can come back and have your mediator further assist you with finalizing the settlement if, that would be helpful. A lot of mediators are very happy to do that. So let's get some thoughts from Ed and Jennifer on this, and then we will save a few minutes to answer any questions. So Ed, what do you think?
I think this is extremely important. What happens a lot of times is you think you've got a settlement and everybody's tired and they want to go home, and yeah, okay, we're all set. And then what one of a mediator I enjoy, Leo Pappas, used to say is, don't give me these oh by the ways, later. And what he meant by that was, don't save it all up until the last minute or the next morning to say, oh, by the way, I need this in there too. You can eliminate that, I think, by or that sort of indecision or that sort of second thinking about the document and what all the terms are going to be by addressing it on the day, at the end, when it's agreed. I think Carol's advice about coming in there with a list of all the terms that you want to make sure are included is really crucial. Because, and you may think of more things along during the day, but you want to be of those things that you really think need to be covered in a settlement agreement. You should go into the mediation with them, whether you provide it to the other side or you keep it, ready for the time that which you enter into the agreement. Either way, insofar as this 664.6 is concerned, if the parties sign it, if you can get it on the record, you can just do it on the record, read into the record, and the parties say yes. But if you're not in a position to be able to do that, it's not litigated yet, there's no litigation yet, or you're not near a courthouse or whatever, then you can do it in a writing, and the writing needs to be signed by the parties, and then it becomes enforceable. And one provision you may want to put into it, which is specifically listed in 664.6, is a request that the court retain jurisdiction of the matter once it enters judgment on this this settlement agreement, which is the whole point of that section of the Code of Civil Procedure. It retains jurisdiction to enforce the terms of the settlement agreement. Why is that important? You do not want to have to file a lawsuit on a contract that you entered into, which is the settlement agreement. You want there to be some sort of court jurisdiction of the whole thing to interpret the terms that you've agreed to, because if you have to file a whole new lawsuit, you really kind of lost your goal.
Jennifer, your thoughts about written resolution late into the evening?
Yeah, no, I agree with everything that's been said. It's really important to get at least the key terms, written down, memorialized, signed. And sometimes these non-financial aspects of the agreement are just as important as the financial aspects, and can be, heavily negotiated as well. And so, sometimes when you're getting close to, thinking you're going to agree on a number, it's important to make sure that you're talking also about these non-financial aspects of the settlement that are important to you. So, I agree, don't wait till the very end and you think you're done because you've agreed on a number, because maybe you're not done. And so coming in with your list of must-haves, whether it's from a financial perspective, or must also include your non-financial key terms.
All right, so I would like to just open it up to our audience a little bit and see if anyone has any questions. Please do feel free to post it in the chat, or if you're so inclined, if you can turn on your microphone, we'll be happy to talk to you, and we'll give you a minute to do that. And while we're doing that, I just want to remind everybody that this is part one of our presentation on successful alternative dispute resolution for your company. And we will be hosting part two, which will cover arbitration. So if you have some thoughts or questions about what you would like us to cover, feel free to shoot us an email. We'll be happy to consider that. And then look for the message, look for the invite so you can join us. So I do not see any questions. And so I'm thinking that we are probably ready to just wrap it up. Oh, wait, I am seeing a few questions. Okay, so here's one. What is a typical mediator fee? Good question. I do think it varies quite a lot. I've seen some people at one end of the spectrum who will charge a couple $1,000s for a 4-hour mediation. And then at the other end of the spectrum, $25,000 for an entire day. And it depends on the complexity and the person's experience. Some mediators are very specialized in being able to handle very complex disputes involving a large number of parties. But Ed and Jennifer, what have you seen on mediator fees?
Well, you kind of hit the range. I mean, a lot of it depends on demand for the for that mediator, and I mean, it's just like anything else, it's supply and demand. And if the mediator is sought after, then they can, set their price and
Yeah.
and fill up their days with people who are willing to pay an awful lot of money because they think the skills of that particular mediator are worth it. So it's a supply and demand thing.
Yeah, I agree. And I, just being a skeptical lawyer as I am, sometimes think, oh, it couldn't possibly be worth it. And then I have mediated with some of those people and found them to be quite effective for a multitude of reasons that I really, didn't necessarily anticipate. So I think, what you said earlier, Ed, is very true. Reputation, doing your homework and your due diligence on people that you're considering to serve as a mediator is very, very important and helpful. So let's just wrap it up with any closing thoughts, and then we will let everybody go for the day. Starting with you, Jennifer, anything you want to leave us with?
Oh boy, I don't know that I have anything particular to add to what we've already discussed, but I think mediation is a really useful tool for dispute resolution. It's often very effective, even if you don't resolve a matter at the mediation. The silver lining is that it's always an opportunity to learn more about your case, to learn more about what motivates the other side, the underpinnings of what they value. And so even an unsuccessful mediation can be very valuable and productive. So I do think that it's, for the right, almost any matter, I was gonna say for the right matter, but almost any matter, it may be something that should be given some good thought as to whether it makes sense.
Ed, did you want to leave anyone with any closing thoughts today?
I couldn't have summed it up better than Jennifer did. The concept's great, and so it's just a matter of how it gets implemented. But the concept's good. Having a third party sort of look at two people who are warring with each other and say, "Well, get real," to both sides.
Yeah.
Well, thank you, Jennifer and Ed, for being with us today. And it's been my pleasure to do the presentation with you guys. And so we will be signing off now, and we will see everyone at the next presentation.
Thank you all for coming.
Yes,
Thank you. Bye-bye.